make sure this, I think I gotta redo that. Otherwise, I'm just not gonna use it. There's a dupe here. I'm trying my head fixing them. I'm gonna go back in and come back out, okay, guys? Hang tight. Hi, Dimple, I see you. I see a bunch of you. Hold on. I'll end it. I'll come back in, okay? I think I can do that. Maybe I can't. Maybe I just need to close it down. We'll see. Okay, I want to hear it to see if it's duplicating sound. Can you guys hear me? Dimple, can you hear me? I see George. Guys, just plug in yes, RD says you can hear me. Awesome, and I don't have the duplication. Okay, I think that was a browser thing, so I just closed it down. Okay, so good to see you guys. I see Sarah Joy. Any relation, Sarah? Just wondering. Joy is my birth name. Stephen Pomeranning. Am I saying that right, Stephen? Johnson, good to see you again. We have an anonymous YouTube user. That is all fine. Yeah, last week, YouTube user, there was, StreamYard said there was some sort of update to like 3 different browsers. I think they said it was browsers that was causing some sort of conflict with their certain things that they had. I see George, Graham, RD, Michelle M, and YouTube user told me that yes, you can hear. Okay, awesome. We'll get to this in just 1 second. And I just wanted to share with you before we get started. Of course, no, I don't have it up because I closed my browser. I was going to just go over a few videos that are coming out like in the next days in case anyone wanted to grab one. Obviously, tomorrow's Friday. We have Friday Fraud Law Review. This was a crazy case because it was a Texas SSA staffer who conspired with a bunch of single moms with kids with no baby daddies and would take a dead man and have the lady claim that her kids were his under his social so that the kids would get the survivor benefits and the SSA staffer down in Texas there would like keep half and they'd get half or something like that. Can you believe? It was pretty, it was $3 million, I think. Anyway, that's tomorrow. We're going to be talking about when you have to prove, or you should be trying to prove, that your need for bed rest prevents a full workday. It could be bed, it could be a recliner, guys. I also was responding to someone who had asked me, and this is purely anonymously, a little bit of buyer's remorse, won the case, won some nice back benefits, but a little resentful about having to pay the attorney fee. So I go into that and I give a little tough love about it, but I do understand how people feel. I just need to show them the perspective of contingent fee agreements and how they are there just to protect the claimants, particularly when they're capped as well. Okay, and then we have this amazing new court ruling about fibromyalgia. And it was remanded because the judge completely disregarded so much, which some judges do when it comes to fibromyalgia, which is not well taken with some of them. They just seem to think it's all fabricated or psychosomatic. So those are some of the upcoming ones. Another upcoming one, I'm just going to mention it for our veterans. It was a question about, like, if you are unemployable with the VA, and why would that not necessarily be a slam dunk for SSD? And we talk about that a little bit because that is a little bit different than 100% PNT. All right, so those are some of the few coming up that we decided to go into. All right, so let's get into it with you guys. Stephen Pomeranning. Am I saying that right, Stephen? Good afternoon. Wanted to ask, oops, let me click it on so you guys can see it. There we go. Good evening. Wanted to ask about many of us going backwards in sequential steps over the past 5 days. I have no idea, Stephen. I haven't even heard of that. I might have had someone said I think I did see someone say that. Maybe one of my clients, they saw something in their SSA messaging. Is this a glitch on the SSA portal? I don't know, because you got to remember too, when they talk about steps, there's the sequential evaluation process steps, which are the 5 steps once it's at the DDS, and they're the steps that are required to determine if someone's disabled. Then you have these like self-proclaimed steps down at the field office, and they're different. So they have their own, and I don't know if they have their step 1 and they shoot it off to the DDS, which has 5, and then it comes back in and is at step 2 at the field office, which obviously has nothing to do with the battle you're fighting generally. For those of you fighting SSI, SSD, initial claims, and or CDRs, you know, your battle is all medical proof, right? That you are medically disabled under the rules during the time frame required. So I don't know, Stephen, what steps they're talking about. When they start shooting them out like that, they make no sense. I mean, how about the one that I'm always watching about, which is they said that a medical decision has been made, and now they just have to review to make sure I still meet those non-medical criteria, which, of course, if you didn't meet the medical criteria, there is no reason, and never has been, for them to try to determine if you meet non-medical criteria. You know, it's irrelevant because you can't get Social Security disability or SSI. So it's very frustrating. But unfortunately, I can't actually tell you the answer. But Stephen does say he was denied at recon and have an ALJ scheduled. Okay. So I think those steps mean nothing because you said an ALJ scheduled. Does that mean you have a hearing date already? That might be a glitch. I mean, miracles and miracles. It would be the ALJ gave you an OTR and it's all done and it's back at the field office and you just haven't gotten the OTR decision in hand because they have to write it and it takes time. However, the SSA office generally would not be getting that case until after that decision is made and written and filed because it's not really official, not carved in stone until that happens. Very strange. He says that his recon is back open and on step 4 after being denied in May. That makes no sense, right, Stephen? I hear you. If you have an attorney, he can see in the electronic file, he or she, or a non-attorney rep, they could see what it says in there. You know, does it say, because it usually sets up in the header, what stage is that? And I'm just curious if yours says LJ or recon. Because if you were denied at recon, denied in May, June, July, did you just file your ALJ? I don't know. Very interesting. If you find out, Stephen, I would love to hear the background on that. Kevin Johnson, howdy doody. What happened last week? Seems like you got hacked. Show was like 2 minutes. Yeah, I had actually posted it in the comments under the channel if you ever check those out. It was actually my fault. I didn't know what it was, but apparently, even though I'm on StreamYard, because it's going to stream to YouTube, I'm not on YouTube right now. I'm on StreamYard doing this, but it's hooked to YouTube. And whenever we put up a video or a live stream, always my videos are not, quote, not made for kids. You have a choice, made for kids or not made for kids. If it's not made for kids, not a big deal. It's not that kids can't see it, you know, but no kid would be interested in this stuff, right? But it's just, I think it's probably for the purposes of advertising and stuff like that. And if it is made for kids, you probably have to do a lot more checking. They're going to be a lot more serious about it. Now, mine are not made for kids, so I just say, don't even bother because no interest. Not that I don't have an interest in kids. Love my kids, love all kids, but not for, you know, they would not be interested in this topic, in this subject matter. So that apparently I didn't click properly. When YouTube posts that there's going to be a video hearing, I have to get in there, little did I know, and make sure that's clicked the right way. I don't even know that I did that with the others. Maybe it just ended up being that way. So you live and you learn, right? We've only been doing this a few months. Yeah, YouTube user, that was another thing. That was actually separate. I thought that was maybe the reason at first until I figured out the comments are not allowed. That was what you guys couldn't see, and I couldn't see any comments, and you guys couldn't comment. No comments are allowed if you don't click not for kids. And that's why and I didn't know it at the time. So I was like, well, I'm not going to keep you guys hanging. Let's boogie out of here and call it a day. But that's what it was. And that was not StreamYard's glitch that they had announced in this banner on the top like a week before. And I was a little concerned that might interfere, but I don't know that it did because I know that it was my glitch, my error that did it. Dimple, how you doing there from Ohio? Sarah Joy says, they said they're going to have to correct the DOD, date of disability. Is that what you mean? I think we usually say that's EOD. Well, you have AOD, alleged onset date, and we have EOD, established onset date. And of course, I suppose you could call it DOD for date of disability down the road, but it's going to be the same as your established onset date. And I need to send in all my pay stubs from the current employer. Okay, I'm going to do as asked, but I'm so confused. Okay, this is fine. Don't you worry. They are seeing, it could be, they are seeing earnings on your Social Security earnings statement that exceed SGA and are after the alleged onset date you put on your application, Sarah. That could be the case. And they're saying, well, tell us what you were doing. And we can look to see if it was SGA or maybe it was subsidized work, even though it was paid more than SGA and therefore it doesn't count as SGA. So they give you all sorts of opportunity. They might have given you an 821 form if your work was W-2, or an 820 if you are self-employed, a gigger, or have a business or something like that. So don't be too concerned. The pay stubs will show how much you made each month, kind of in a roundabout way. So, or let's say you have a pay stub, but you're out sick getting paid sick time for most of those days. That's not really work activity earnings, that's sick time. So all these things can help you get that alleged onset date legitimately back to where you want it, or you'll realize that, oh no, I didn't realize that I was making too much and that I cannot be fined disabled before the date I stopped earning too much. Okay? Hope that helps, Sarah. George says, hello from Punta Gorda, Florida. Thanks, Stephanie. Everyone hit the like and share. That's very nice, George. I agree. Please do. Okay. You guys are telling me that the sound is good. Excellent. Michelle M., I appreciate. And George. Karen White is in the house. And Karen says, are there more CDRs being scheduled than usual? Also, the long form is being requested more. I have not heard that per se. However, I think we talked about this. Maybe it was just online and not here, or with somebody on the phone. They had halted, Karen, for nearly 6 months, I'd say, all CDRs. So all those full CDRs got a 6-month reprieve, and they did this back in 24 because they were so short-staffed on initials and recons due to the hiring freezes and the great resignation of the early 2020s. And they just wanted to get that backlog so people, with initial cases can just get their case, moved forward. And so they borrowed CDR adjudicators and put them on initial and recons to get those things handled to move new applicants along, as opposed to only dealing with CDRs to, see who might not be legally disabled anymore and has improved sufficiently to go back to work. So I would expect if it seems like an increase, it would be because of that, because that halt ended 2024. So it's been for a bit that should no longer be the case, no haltings. So yeah, they would be obviously doing what they have to do under congressional law, which is, doing the reviews and making sure that the people that are recovered and forgot to mention, get checked. Everybody gets checked to see which one of us are those. And I will say, I'll just be a reminder, guys, CDRs don't cease a lot of proportionally very many people at all. Probably a little undercutting versus being where it should be. I don't know if that's going to change. I just don't know. There's been so much fraud lately of the last several years. I think that's a concern. So we'll just have to see. Okay, Lionel. Hi, Lionel. Hello. Oh my gosh, Lionel, I was approved yesterday on my reconsideration appeal. As I mentioned before, my recon was denied, yet I got it reopened and now approved. I wish I could send you my lawyer's. Oh, that's super sweet. Just positive thoughts is good there, Lionel. And you showing up all the time is good. You help me more. Oh, that's really, really sweet to say. Lionel, you say refresh me, and I don't know if you feel like typing it here, we'll get to it later, but you got it reopened. Was it because of no review, or because usually they tell us the common thing is, no, your avenue is appealing it. If you think they screwed up, well, obviously that's what appeal is for. But if there was something where you were denied a recon in substance in some way, or form perhaps, I wonder if that was the basis for the reopening. What was going on there? Or I wonder, think about a technicality that could be a reason why a recon was faulty. Not because of the end answer. Let's say on recon, suddenly they're saying, well, the disability period claimed is starting on this date to this date. Or they think it ends because they think you have a remote DLI, date last insured, and you don't. Or it's not the date they said. So they only looked at this tiny period when they were supposed to be looking at this bigger period. That I could see being a recon failure because they didn't actually recon you on the full period that they're supposed to be looking at. So that's possible. I'm just wondering what yours is, Lionel. And I'm so glad for you that you prevailed. Way to go, buddy. That is awesome. Oh, YouTube user says, how can you put my name on YouTube instead of anonymous? Oh, gosh. I think you have to go under your YouTube account and poke around with some of the settings, is my guess. If anybody wants to share, you're a little more techie than I am, obviously. Hi, Wayne. Wayne had a question. This is Wayne Corder. Nice to see you, Wayne. Had a question. Will be 54 next month. Will that make a difference in a claim? No. Actually, Wayne, 54 is no different than 53. Just saying it like it is, right? If you're 54 in 11 months or 10 months, it could potentially. Second way. All right, so let me scroll back to Steve. Second, is this a glitch on denied at recon and have an ALJ scheduled? Okay. I'm not sure what else I asked about second way. Yes. Okay. I'm just going to bypass that, Stephen. I'm not sure where I'd be responding. Okay, so Ann Me says, what does it mean when a case goes from step 3, the medical step, back to step 2, as if step 3 never happened on the online portal? Again, we were talking about this earlier. I don't know if you were here a few minutes ago, and me. It's not clear what steps they're talking about when they do that, because there's at least 2 different sets of steps. When you're at the DDS, that is a 5-step sequential process. Are they referring to that, or are they referring to their internal little, what they know to be their little secret steps at the field office? It's hard to say. I don't know. Step 3 and then back to step 2. Now, in theory, let's say that was a sequential evaluation process. So if a person has You wouldn't go back to step 2. That's about medically determinable impairments and severity. Step 3, do they meet a listing? And if not, get an RFC. Why would you do that and then go back to step 2? As if something's not even a severe MDI, medically determinable impairment. So I don't know that they're meeting the steps in the sequential process, because that would make little sense. So I'm thinking, could it be that I don't know, did you already finish? Little do you know, maybe it's no longer at the DDS and it's back to the field office. DDS made a decision. Or is this just ridiculous messaging glitch? We've had them for a few years now. So stands to reason it could be again. The technology and the messaging combined might be doing some wonders. But that's really all I can say about that. Steve, you're saying, Stephen Pomeranning, there is an entire Reddit with hundreds of people being affected. Affected by which now, Steve? By, let me just scroll back up again. Oh, you talking about the backwards and forwards with the numbers? Again, I feel like that's got to be a mismessaging. You know, unless there was something awry with step 2. I can't imagine how this could even be. And they had to redo everyone that's in there right now and that had moved out of it, step 3. That's the only thing I can think. But that doesn't make sense either. So the questions linger, right, Stephen? Umo. Everyone's doing great, Umo. How are you guys doing? I hope you're doing well. Steven's saying, I got a denial, so I completed step 5, right? Because you got a denial. He's saying a denial on recon, right, Steven? So it went through step 5, which it has to go through step 5. Unless it's going to award you, they have to go through step 5. And he got a denial. And he appealed for an ALJ hearing, but now both the hearing and the recon are both open. Yeah, that sounds like a real mess. That sounds like a mess. What I would do if I were you, and I would just say this to anyone anyway, keep doing what you're doing in terms of treating for big things, big and small impairments with specialists, and keep bemoaning your symptoms. Don't be shy, don't be Superman. And that's the part that you can do that you have control over to some degree. And hopefully your doctors are recording them well so that when things are back on track, whichever way it's going to go, whether they have to do a new recon because someone, I don't know, what if you have some like radical weirdo up there that is making everybody denied? And adjudicator's like, wait a minute, I had my case and I wasn't done. I mean, I'm always just thinking, who's got the power over the buttons, right? Now I'm making that up, people. I'm just kidding. But you just don't know because you don't know, right? Sarah Joy says, field office called collecting more information regarding work history, verifying the non-medical is still meeting requirements, stated by SSDI amount each month. Ooh. And then Sarah goes on to say, after verifying work history, they said they're going to have to correct the DOD. Okay, DOD, so they're calling it the disability onset date or date of disability, however you want to use that little acronym. And I need to send it on my pay slips to my current employer. Okay. Sarah, it depends. I would be able to answer this better if I knew where you were at. Were you ever at the DDS? Did you complete a work history report that was paper sent to you from the DDS? It would have happened when you received a paper function report -adult, the SSA 3373, which gets mailed to you in paper format from the DDS adjudicator, which is a different office than the field office. So I'm wondering, if it has not even gone up to the medical office, they do a lot of this stuff before they send it up. They have to have a firm date that is going to be the alleged onset date, the earliest possible date that the adjudicator should be looking at to determine if any of the medical records prove disabled by that time or any time thereafter up to your date last insured if you have one, presently or in the past. That has to happen. So this could be happening now, early on, or if your case has already been up at the DDS. I have had cases that were at the DDS but had to be stayed momentarily to get something fixed about working. It might have been because the person went back to work and they had to make sure that it wasn't SGA, it was probably self-employment. And that, of course, requires more inquiry because, people are able to use their discretion with some of their financials. So that isn't terribly unusual. Even if you're at the DDS, it might go back and they ask for more information because they have to really, the DDS does not get to decide what the alleged onset date is going to be. That's the field office. So if that was getting a little wonky, that's probably what they had to do to get a firm one so that there's firm dates that are being adjudicated by the adjudicator. I hope that answers something. Sarah. Yeah, and pay stubs will help. That's going to show your hours each month, how much pay each month versus when they get more of a bulk number, or you just said that you're working, or they found out you're working, they don't know how much. Steve says hearing, I think in October. So the hearing was scheduled and now they're both disappeared. Interesting. Rat's Nest, good to see you. Have my CE next week and super nervous. I do have couple videos on just some guidance on consultative examinations, Rat's Nest. If you haven't seen them, feel free. Everyone's nervous, so join the club when you go to a CE. I recently got some testing and blood work done that came back positive for autoimmune. How recent to exam would they have medical records? Should I bring new ones? Oh, well, in case you didn't know, the SSA generally barely, if ever, shares medical records with the consultative examiner. It's a bit of a travesty. And this is, when they do, it's usually a few pages. Sometimes it's a completely, what I would call, immaterial report, not a material report. Depending on the case, sometimes, yeah, like maybe you do want to bring in your blood work for autoimmune because the DDS probably doesn't have it yet. It's not going to be before the CE. It's going to be that you don't have autoimmune or it's not even alleged. So maybe bring that and say, I have autoimmune and my doctors, and here's what my symptoms, but now they will know that you're probably going to be, because of the lab work, objective lab work, and all the other ways they diagnose a particular autoimmune, if they've even gotten that far, it takes some time. The blood work is the best start, though, because it's objective. And then obviously the symptomology has to kind of fall in line with that and everything. So, yeah, I think they probably, if you just had some recent testing, I think you can, I would go with the presumption that the DDS doesn't have it yet, and if they do, they're not sending it to the consultative examiner. That's what I would say. So that's a good objective thing to say. I have autoimmune, so here's my blood work. We've been working up this for 2 years because I've been so limited and so this, and nothing was clear. I didn't have any broken bones, and now we know it's apparently autoimmune. Steve says, I filed for the ALJ in May as soon as recon was denied and have a date in October for the judge. Okay, they're going to get it cleared up. I would keep plugging away, doing the part of the job that you and only you can do, which is the treatment. Really aggressive, very aggressive. Hi, Taylor, nice to see you. I love your flag. On another channel, they said they're doing more CDRs now. Yeah, we just discussed this. I don't know if you missed it 5 minutes ago. They halted them for 6 months in 2024 so that they could work on initial and recons because they were very, very understaffed, given the hiring freeze of a few years ago. Prior to the hiring freeze, or maybe, yeah, probably prior to the hiring freeze, was the Great Resignation, where DDS people were walking out the door. And yeah, so now they're not necessarily more than they used to be, but they are more than zero, which is what they were for the 6 months. And that's been the case. They started doing the ones that were supposed to be done last year. Now this current Social Security has to pull up the slack from the slackiness of the year. Okay. Stephen's clarifying for me, but now recon is back open on step 4 after 3 months of showing a denial. Stephen, I have no idea, but it is really interesting to hear you guys all talk about this because clearly something's going on. So I look forward to finding out what it is. Sarah says, for historical purposes, I appealed my first denial. I appealed my first denial. The second appeal went to state and was pulled for quality review and is now back at the local office. If it's quality review as opposed to non-medical review, Sarah, that's often a good sign because often it seems that when something's going to be quality reviewed, it's because the adjudicator wanted to award and they do a random audit. And I get the sense that they do more of awards versus denials by an adjudicator. So nothing about that in writing though, just my sense. Kelly says, yeah, Kelly, I closed out. I don't know if that was what you were referring to. That was really early on though. Okay, but thanks for letting me know. What can your child or spouse get once you get approved for SSDI? If your child is a minor, they might be eligible and likely will be VG for a dependent benefit, which could be up to 50% of your benefit, but not taking away from your benefit, just on top. So it really does help you keep your household together. Your spouse will only be eligible under certain circumstances, such as if she's the caretaker of a child 16 or under, which means she doesn't hold down a full-time job elsewhere or work whatever that earnings limit is. Oh, I see the lighting's changing. It's getting darker outside. See all the fuzzies around my head? I have no way to fix that. I have no idea. Okay. Otherwise, spouse can collect early retirement if they're old enough once you collect SSD. Not that I necessarily recommend it, but they can. They'd have to be 62. Okay. Me, Heidi. How you doing? Do I remember correctly that you said at one time that we can request a copy of our SSA file after we were approved? I would like to have a copy from my files if possible. You can always request it and you can always get it. If your case is closed and you're not pending appeal or thinking about appealing or whatever, they might want to charge you. And I heard it could be like $1.20 by some, which I think is out of control. And then in other places I've seen $10. Yeah, you can. You can use that SSA 3288. I have a copy of the one we use or we offer, I should say. We don't actually use it ourselves for the most part. On the joydisability.com site under forms, you just kind of have to dig for it. It's not something you can look it up too. It's just that we have extra wordage in there when they say you're not allowed to ask for your whole file. We're like, yes, you are. Check your own palms, fool. And we attach the palms to inform the the staffer who has no clue about their own rules. Okay. Oh, Sarah, you're very welcome. Sunflower 9999. Just got an initial denial. I am very sorry, Sunflower. Finding able to do light work. This is impossible, but my question is, do you find that the ALJ level consideration is given at the ALJ level, consideration is given to limitations, time spent in bathroom, etc.? Absolutely, if you have objective medical evidence of that, in addition to your own assertions that that is how your schedule goes in the bathroom. I would keep a bathroom journal, like a calendar, and then you're going to want to get that maybe to your I don't know if it's urology or for whatever reason, it could be GI that you're in the bathroom a lot, so that they have, whether they ask for it or not, they have now, from the horse's mouth, how many times a day for how many minutes, basically each time you're in there. And if that's a few hours a day, in an 8-hour day, if you're in there for 2-3 hours, that is going to definitely interfere with being able to do a full-time 8-hour a day job, because you're not even available 8 hours out of 8 hours. So while they won't, like if someone uses the permitted breaks, like 15 minutes in the morning, half-hour lunch, 15 minutes in the afternoon to go to the potty, probably will not be, that's not going to be a problem at all with a job. And some VEs I think will say 1 or 2 more trips probably if they're short, but if you're in there, every 45 minutes outside of those breaks, and you're in there for 20 minutes, IBS can do that. I think IC might do that. Then, yeah, that could be interruptive of a day. So I would keep a calendar. I would also verbally reiterate it every time I see the doctor. I would probably fax into him my little journal and say, this is how bad it is, doc, because then it presumably is going to be in the records that get sent to the SSA when the SSA requests your records. And the fact that you're going to the ALJ, remember, guys, the burden is really on you to get your records in. ALJ will ask you for all your updated doctors you've been treating with since they last updated your case, which would probably be recon. And they are supposed to help ask for those things, but I would say that the burden might still be somewhat on you. So if you want your hearing to go up with all your stuff intact, I would get that medical evidence. Anything that from the last time it was in the file to the present, which I know brings us back up to ordering your file. If you are at ALJ level, you can ask the ALJ office. They will get you that file. They are much better at it than the field office. They're much more accommodating. They have to be. They're far more, dare I say, professional. There is that. Then you could see when they last had Dr. Jones, and you know that you had 10 more visits with Dr. Jones, and you're going to want to get them in. And you're going to want to see if Dr. Jones, discusses your symptoms that you tell him about. Because if he doesn't, you might be like, Dr. Jones, my records don't even talk about what I complain about. Not saying you necessarily want to tell him that you're filing an SSD claim, but you might already have done that. Who knows? But yeah, ALJs, if you have the medical evidence, that's why you want it to be reiterated by your doctor that if for 2 years you're reporting that you go to the bathroom 10 times in an 8-hour day, it's probably going to hold a bit of water if you happen to have documented diagnosis of urinary frequency or incontinence or IBS. So that is super important, I think. Very, very important, because it quantifies the symptoms, and it's in the medical record, and it's durational. It's not just in once. You've been saying it over and over again. That's true of all that stuff, guys, all symptoms. Valerie, nice to see you. Have you ever had a case or dealt with a suspected malingerer? I have not, but I'm really good at vetting my cases. I've been doing this a really long time. I do know I withdrew from this immediately. I had just gotten on board, or I was about to, for a woman. And I guess she didn't think it was like inappropriate or a big deal. And therefore she blurted it out to me that I think I must have been on board already, because I don't know that I would have remembered it if I just said, no, I'm not representing you. I probably had to do some things to get myself extricated. And of course, there's attorney-client privilege as I see it. So I didn't talk about why I was withdrawing. I'm just withdrawing. And she was working full-time under the table. Yeah. So that's a double whammy. You're screwing the IRS. Don't get me wrong, I'm not a big fan of the IRS, but you can't be evading your taxes. You have to vote to get those taxes reduced, right? And looking to take from the Social Security Disability Fund. I I'm not sure that she recognized that she was being dishonest. Sometimes people just don't. She probably thought, and I think this is true of a lot of people, I have impairments. I'm in pain. I can't do the work I'm used to doing that I'm good at. And they think that's the definition of disabled. No, it means you're impaired. Doesn't mean you're disabled from all work. And they don't realize that it's all jobs that they have to prove, not just the one they had for a gazillion years. So that would be the closest thing I would say to a malingerer, but I think she was just uneducated. You know, these videos didn't exist back then. Ooh, sorry. I was leaning on my desk and I have a very desk and apparently I didn't clench it very well. I'm going to breathe it back up. Yeah. Helps my posture, you know. Sometimes I stand with it. I have a spare one, but they're really heavy, so I can't even mail it out. Malingerer, yeah. Malingerer to me is like a gross exaggerator, and I don't really see too much of that. I just don't. If anything, I see the opposite. People that play it down, they're so used to, you know, putting on the cover, going out in the real world. You don't want people knowing your business. None of us do, right? Particularly when we're hoping it's going to be a temporary passing thing and we are not going to be deteriorating for the rest of our lives here on this particular earth. So I see people who have been workers, pushing off everything to keep working in pain and probably hurting their body. But I get it because that's what many of us were kind of born and raised to do. And this might not be so common in the younger generations now, but for mine, it certainly was. And I see them playing things down. And I'll even bring it up. When I see it in a record, I'll be like, well, the week of the 4th, you went to Dr. So-and-so, you know, he said that you were doing pretty good. Meanwhile, you know, it was cut off 3 days before or something like that. And I'd be like, well, you know, I didn't want to, you know, I like to be positive and da-da-da. I'm like, no, now is not the time to be positive. Now is the time to be very vocal about your complaints, be very candid and not hide anything. Don't be Superman. Don't be Wonder Woman. Go back and read the facts we sent you at the beginning of your case and start being that complainer that you never were. I go, just temporarily, just to get through this. You know, you have to be honest about how troubled your medical situation is and your symptoms and your limitations and your quality of life. You just have to be honest about it. MBGM, new member, thank you. Awesome. Nice to see. I appreciate very much. And as a new member, of course, you're going to get some of the videos way in advance of just the regular folks watching, just so you know that, and you probably know that. They just get shared right away as soon as they're up, not on the date they're scheduled, because we only do one a day. So if there's 3 in the pipeline from a particular day that just like there was a lot to do and a lot going on, and the time, you'll get those right away. You don't have to wait. Okay, Maeve, hi Maeve. I really need to have a cheat sheet of acronyms for this alphabet soup. Yeah, I know. You know, go ahead if you want ever, Maeve. Message me, any of them, and I will be happy to go through them for you. We do have a glossary playlist, but I think it's been neglected, seriously neglected. So anything you need to know, you can even ask it on here, Maeve, and I'll give it a go. Sunflower says, also, my doctors aren't documenting the relevant things I'm saying to them during appointments about my limitations. What's the best way to ensure they do? Oh my gosh, I know, Sunflower, that is so frustrating. What I often say to people is, and my clients, use your portal messaging system, get that message of all your complaints before any appointment and or in the interim when things are just bothering you and you just want to, doctor, I just want to let you know this ahead of my next visit. This is going on, this is going on. I am going to the bathroom. Like if you're the bathroom person, even more than I was before, it's getting worse. That Lasix or whatever, no, the opposite of that isn't working. Portal messaging, one way for doctors that, and most of them probably do now have portals. If not, perhaps do it in the form of a letter and fax it to the doctor's office and say, this is for my medical file, so the doctor is aware of my continuing problems pending my next appointment. Keep your fax confirmation. And then when you get your medical records, darn well that better be in there. I mean, patients' complaints are, of course, part of the medical file, and if they leave them out, I know there seems to be no recourse for this kind of sloppy stuff, but I suspect there is. There's just no one. I mean, one could sue for, you know, you promised me you would be diligent, doctor's office, and you weren't because you didn't even record my complaints. And that's a basic form of medical acceptability according to the AMA or whatever. Get your research together. But I don't know. There's got to be some way. I suppose the thought is, well, there's no damages usually. But when it comes to an SSD claim, there could be damages. A lost case. That's pretty big damages. I would like to see something where the violation alone, if not rectified within 30 days of the person asking for it to be rectified, is in itself comes with a monetary sanction, and potentially to the patient themselves. Although sometimes in these kind of things where they have those kind of sanctions, like for instance, guys, the Consumer Protection Federal, I forget the acronyms. I'm always so interested in it though. When you are kind of defamed on your credit and certain rules within that obligation they have fails. It's like a few years back, and there was like a little cottage industry of lawyers that would take these cases, and I thought it was great because A, there was like $1,000 fine per breach, and B, attorney's fees could be awarded to the patient claimant or the consumer claimant. And that means that the other side has to pay the attorney's fees once that claimant prevails and proves that they were right, that their rights were violated. And this gives incentive for people to provide that service because they can actually make a living out of it, because they don't have to find a claimant that's going to throw $10,000 at them. Who can do that? They can get the attorney's fees from the guilty party, I suppose. And that, I think, I love those kind of laws because it opens it up and it causes a lot more accountability to the violation entities that continuously violate. I would also like to see that in some of the HIPAA access laws. We have the Office of Civil Rights, which enforces the HIPAA, including the access laws that I'm always babbling about, including the high-tech HIPAA, which is my favorite. And there's no bite to that to speak of. When a company, medical provider has egregiously violated forever, I guess as a uniform course, and everyone has complained to the Office of Civil Rights, they probably try to settle, but if not, they sanction them to the tune of hundreds of thousands of dollars. They don't represent each individual. So when an individual, has a problem, they can file a complaint, and I urge everyone to do it, to the OCR. And the OCR, I believe, at the very least, does send maybe a letter to the alleged violator saying, someone's complained about this. You might want to fix it or respond. And I think that alone can get a light underneath the tuchus of some of these. But if it doesn't, then what happens? And then people often just don't do those things. Although it's like a 3-minute form, guys. It's really easy. You could even email it to them, to the OCR. It's great. It's on their site. I hope that helps, Sunflower. I went off on a tangent. Lionel says, my recon denial letter did not list my most important medical records. I went to the office with the missing records, and within a week it was reopened. Interesting. Normally that wouldn't be what happens, Lionel. So I almost feel like that's a miracle, because when you didn't previously give them the missing records, or maybe you had proof that you did and they didn't include them, if you didn't yourself take it upon yourself to bring it to them, then if the SSA did ask for everything on your application or on your initial denial form that you said was to be updated, if they requested them and your providers didn't provide, they're kind of off the hook. So it's up to you to make sure those get in. So I'm surprised that I'm glad for you. First of all, I'm glad for the end result mostly, but I'm glad that they did that, but I'm curious about it because you don't really get to reopen stuff if you forget to send in your records when you should have, and if you're pro se, that is your obligation. It is your case. You run it, you snap the whip, you get the medical records and you send them in unless you've seen that the SSA was able to get them. And you can't really see that. So it's kind of hard for pro ses at this juncture anyway, since you can't see what they've gotten in. And not to mention on the denial letters, when they say what they got in, they just say the report received. First of all, it could be like, it's not a report, it's medical records. So their verbiage is poor, and it doesn't say from what visit date to what visit date. Like, you don't know. And maybe they ordered this in the beginning of your review, and it's been 6 months later, and they don't have the last 6. So a lot of imperfections, right? Not a perfect system. Tony P., good to see you. I was stuck on part 4 of the process for 2 months. I had called the field office. The lady was out. They told me that I will have my award letter the following week. Woo! That's awesome, Tony. 2 months, part 4. Can he do his prior work? All right. That's awesome. I'm glad for you, Tony. Yeehaw. And these are people, guys, that are winning on initial and recon that we're hearing from today. So I had heard that there was going to be a push, and maybe we're seeing it now, to get a more serious look on initial and recon so that all the people that go to ALJ hearing, if there had been a better review, might not have had to cog up the ALJ queefers. So if they are taking it more, if they're doing a little more serious, review, then I'm happy for it. It might take a little longer because haste makes waste, but maybe that's what we're seeing, that they are taking it a little bit more seriously these last months, and that's why maybe initials and recons are up, awards you know. Okay. Oops. Sorry, Valerie. I just bleeped you out by accident. I've always received the short form of CDR. My attorney told me that it's hard for Social Security to stop your benefits then to initially then getting on it. Is that true? Okay. I've always received the short form. My attorney told me that it's hard for Social Security to stop your benefits. Yes, totally true. And this is why most CDRs pass with A-OK. A, because most people continue to treat because they actually have real problems. They're not malingerers, as we were talking about before. And yeah, the burden shifts. Once you've already proven you're disabled, and I'm not going to be able to clarify which, I think the burden is on the SSA to establish that you improved, and so it's not your responsibility to show that you didn't improve. They have to have a reason of evidence to show that you have improved. And by the way, failing to go to any doctors would be evidence of improvement. Not conclusive, doesn't have to be conclusive, evidence of improvement. So that is their burden. And you can easily have them fail at that by continuing with, reasonable treatment in reasonable time frames. So there's medical records that will show that you're still complaining about XYZ. You're not doing, jumping jacks and handsprings in your doctor's offices just because you're done with your disability case, So yeah, it is. The SSA has a much higher, by law, so they're by law or by regulation, they have the burden of proof that you had before. Oh, Valerie, I'm looking at, you have been a member for 12 months. Hey, that's pretty awesome. Has it been that long, Valerie? We're like old besties at this point. That's a long time. Yeah, that is a long time. Okay, I guess because we only started having them. You must have been one of the first. Thank you. Yeah, CDR, it's harder for the SSA. They have a higher burden. The SSA rules say they have a higher burden of proof in the fact that they have to prove that you've improved. You don't have to prove you've not improved. But if you give them the opening to prove that you've improved, that you have improved, then you're going to have to fight back and say, yeah, but not really, and or not enough to work any jobs full time that exist in substantial numbers. We do have a playlist, or at least I think it's a playlist on the 8 steps to the CDR process. It's kind of interesting. Keep in mind also, CDR uses your new age if you've changed age category, so that's always helpful. And if you have new impairments, those can be taken into account at some part in that 8-step process of CDR education. So there's a lot of reasons why people generally don't get seized on CDR if they're doing the basics that we're always telling them to do. If you think everything's, hunky-dory and now it was a lottery ticket and I was able to win it. I won the poker game and now I get to go home and not doing it. That's not true. You have to keep up your case. Okay, Darren. I don't think we've met Darren Magaha? Is that right, Darren? I'm 57. You and me both, Darren. EED education, unskilled work, 58-year work history. Now, Darren, if you're 57, how do you have a 58-year work history? Did you mean 38? Just wondering, or maybe, I don't know. I feel like most of us, we started in our teens, right? Left knee is bone to bone, total knee replacement recommended, hypertension, bad back with MRI, arthritis. What do you think my chances? I think if you have a properly worked up medical, current, robust treatment with specialists, I think you have a good chance. I think that sounds like a very, under the grids. Yeah, I do. If you don't have an attorney and you think you need one, definitely, you can see down here, free eval review. We're actually adjusting that on the website to have one portion of the categories kind of like separated out for people, but we'll see how that goes. I don't know. But yeah, you could fill that out, and if you wanted assistance, you could certainly inquire. And if you say in that eval that you spoke with me on here on this day, they will get it right over to me, and they won't even go through that preliminary review. So you could feel free to do that. Tony P. So I was approved first shot during this blind also. That's awesome. Also, I didn't apply for SSI. I would assume that would open a can of worms if I tried it. Not really. If your SSD amount is going to be less than the SSI amount, or technically if it was even the same, you would be entitled to a teeny tiny bit of SSI, assuming you were otherwise broke enough assets, countable assets, resources, and other incomes, including a spouse. That might not be worth it. I mean, if you were poor enough for SSI because you had no other income and you don't have countable resources over 2,000, Tony, that 5-month waiting period that they're going to stick you with for SSD, it's just a matter of law. It happens to all but one or two types of impairments. The 5-month waiting period could be that you would get the nearly $1,000 a month for those months if you had an application in. But you didn't, so it's too late now because SSI can never go retroactive before the date you apply. So I always think it's something to look at, because if I can, nail for my client another $5,000 just lying on the table, and then your SSI is over, you're not even on it again because your SSD overwhelmed it, and you're no longer eligible for the SSI, but you got them for those 5 months. That could cover an attorney fee. A lot of attorney fees, even though we have the $9,200 cap, most I'd say do not hit $9,200 because of the, it's still 25% of back benefits, which if it's less than $9,200, you're not getting $9,200. That's a cap, not a floor. So, I always try to grab whatever, because the more that we can leave in the client's pocket, that's our duty, right? Darren, yeah, 38-year work history. I said, I know you're working hard in your mom's belly, but it doesn't count. Yeah. If you haven't applied, you probably should. If you plan on using a representative, I suggest you get them before you apply. The chances of prevailing on initial or recon and not having to go to ALJ, I think, are much greater because the job is done right. There's none of those little things forgotten or misstated or inconsistencies that, end up causing a denial. And if any of your evidence is weak, the representative can discuss that with you and say, listen, you're going to want to get, this to cover this little gap you have. Hi again, Wayne. Thank you for answering my question. I really enjoy your videos. Oh, thanks, Wayne. You too. RD says, hello from California. How much notice will get to see an SSA doctor? I believe I'm at the stage for medical review. I always, on the occasion that I happen to be in a conversation with an adjudicator and I learn that they're going to consider doing it, I always say, can you please give them at least 2 weeks notice? Because they need to schedule a ride a lot of the times. A lot of people can't drive all that way. If it's 45 minutes or an hour, it's too far for a lot of people to drive. And they might have an important doctor appointment. What if you have that neurology appointment where if you cancel, you're going to have another 8 months before you have another one? That's really harmful to your case. So they're very understanding of that. If it's, if it's not, if it's just, let's say it was one PT appointment that you're going to just reschedule the next day, then I would take the CE exam if they schedule it. But if it's something important, you might want to get it rescheduled. They'll do it one time, I think. I like them. It's probably the only thing I feel is okay is in our area, it's the IMA group that seems to use Tri-State for these CE exams. And I prefer they schedule with my client so that my client gets to choose. Maybe he doesn't want to be there at 8 in the morning. If he's a slow person getting out of bed, aches and pains and everything else, I'd like to see him be able to say, I'm available, 11 to 3, and not on Wednesdays and Thursdays, and then pick the time that's going to work best for him. Plus, if he needs a ride from spouse has to take off work, whatever, maybe they can do it on a day the spouse already has off. There's so many things that, nobody needs to have things harder than they already are when you're, enduring disabling conditions. And sometimes they are. I have seen them. One time my guy got, and I didn't even get it until like 3 days after this, he got the letter for the appointment. This is in the last year. It was like maybe fall of 2024. And he got the letter on the day of the actual CE exam. So clearly he didn't make it. Yeah, that's pretty bad. So just got to jump on it. And if you need to change it, I would suggest you call right away. And the letter might say whether to call the DDS person or to call the consultative examination. I'm thinking you always want to let your adjudicator know, so you're always going to want to call DDS at the very least. Okay, you're welcome, Stephen Pomeranning. Thanks for being here. Tony P says, one more thing. Am I entitled to get my application workup? So I know what they were leaning more towards what you want, Tony, is your DDE, your disability determination explanation. It's going to show you how they came to award. You definitely want that. I recently had to ask for one and they sent it right away. I was shocked and stunned because I have a client on recon, and as of June 7th, we're supposed to have that whole section that has the DDE's disability determination explanations in it in section A. We never had access to section A. As of 6/7, the whole transparency push and all that, they said section A is now going to be available on the electronic file. It is, but it is hit or miss I think if your case was already existing, they're not up there. So they didn't add them in. They just opened up the file that it's not in. So I had to call and ask for that, and I did get it. I think they had already denied, so we have to go to ALJ. But it is informative. Like, for instance, they're saying this person who was at the relevant time period, was in the early phase, could do medium work. And that's because a workers' comp doctor says can lift 25 pounds. Doesn't say she could do it up to a third of a day. That's 20 minutes out of every hour. Can you be pumping 25 pounds? I mean, I can't stand when this is done this way, but that's just how it is. I mean, all the doctors are workers' comp because it was a workers' comp case, and you're not allowed to see your own doctors in most situations. Workers' comp runs the day, and their doctors are paid by them, so you're kind of stuck with what you get. Obviously, I'm going to be arguing that point at hearing. So yeah, Tony P, you're going to want to ask for your disability determination explanation. You could order that with your 3288. You might be able to ask for it in writing, but sometimes these staffers are like, you need to fill out the 3288, which really legally shouldn't be required if you put it in a letter. But I would just, pick your battles. Maybe just do the 3288. You can also call them and see what they say. RD says, not to sound negative, but these delays are causing harm to the disabled. Yeah, RD, they've been doing that for 20 years. Do you know, RD, that up until 2019 or so, ALJ hearings were a 2-year wait after you appealed for them. So if you think this is bad, this is actually really good. I will say the worst part is the initial and recon right now. ALJ is still not terrible. It's gotten worse since that lovely improvement in 2019, I think because they hired decision writers and ALJs. But now the initial and recon business, so I'm sure they're working on it. Glamour girl, long time no see. I feel like I haven't seen you in a while. Hello, Attorney Joy. If a person meets a listing, do they need a function report? Well, good question. I'm going to say no. However, until you win with a listing, you need to present whatever they ask for, right? Most people who think they meet a listing just don't meet a listing. So I see, kind of people who misunderstand the whole listing thing. They come out the gate saying, I meet a listing, therefore they're stupid for not, and it's like, not so much, not from what I'm seeing, it's going to be the RFC way. So in which case the function report would be part of helping define the residual functional capacity, at least in the way of saying what you say you can do, not so much the rest perhaps. Okay, Sed Block says, hi Sed, I don't know that we've met, nice to meet you. Why is step 3 taking so long? Well, step 3 is, I would say, the longest step of all, because that's where you have to promptly, pretty promptly, provide a report that they ask for you. They mail it to you. It takes the mail time. It's the function report. Also, usually the work history report. On top of that, they have to order, and your doctors have to promptly provide, which they rarely promptly provide, the medical records. So I will say, I will go in and I will see that the SSA requested from a doctor like every 2 weeks for 2 months. And the doctor's office just hasn't provided. And we will be sending them urges, and the client will be calling them, the patient, to say, yeah, the SSA's asked for this. And then they'll say, we never got it, or, whatever. Well, now you do. And of course, if we send a request also, oh, you didn't get both? There's mail and there's fax, and you just somehow didn't get both, So I don't know. But 3 is the longest because that's where the entire, truly, I'm raising this up again, guys, that's where the heavy work is done. That is where the CE exams are scheduled, and if you're busy and, you can't make it for 3 weeks, then that's another 3 weeks. So, and then by the time everything gets in, nothing can go to the SSA's medical expert until all that stuff's in. And then he can evaluate all the medical evidence and say, this is what I think the person's RFC is. So does that make sense? It is the one that needs all the evidence. And people are slow. Doctors are very slow. Claimants are very slow with their function reports, work history report. Just as a little throw-in, guys, I think if you're starting a case and you're going to be pro se, or if you have a representative that doesn't do this, and we do it, so this is not an issue in our practice, but go online and download the function report and start drafting it. Whether you're going to rewrite it on their form or not, which you really don't have to. You can take that top page that has the barcode that they send you and smack it on top of yours. But that way you can, as you maybe review any function report playlist material and all the different questions on there, and you decide, oh, I really got to change my answer, you could change it on your rough draft. They might even be form fillable. I know we have a form fillable version, which is nice because if you have to change your answer, you're trying to reword it right, whatever it's typed in, you could just, delete, and you don't have to redo the whole thing. anything like that. But that's something you can do to, when you get the demand, you can shoot it right back. You already have your function report already sent to them. No stress on your part, no panic, and you know you have the answers the way you want because you had them. You did them for 2 months. So I think it's a great strategy. Clara Ross. Hi, Clara. Oh, look at those cute little babies. That's really cute. My steps did the same here. It shows at step 2 with SSDI and on step 3 with SSI. I have CE on Monday. Now it's taking 19 months at initial. Wow, that's a long time. But I've seen it myself. Well, you have a CE coming up. That's a good sign that you're towards the end of that process. I suspect in your 19 months, Clara, that you did not have an adjudicator for a very long time. Remember, they were very short-staffed. I'm not saying that they're not short-staffed still. They probably are. But your dice rolled, you rotated into the slot of next on deck for the next available adjudicator, and now you're off to the races. So hopefully you use that time smartly to grow your evidence, get your diagnostics updated. So they had the most recent and probably the one that shows the worst damage. Fingers crossed for you, Clara. Dimple says, I have another doctor appointment and we'll catch the replay. Thanks again for all you do. Oh, yeah, Dimple, I'll catch you later. Good to see you. Always have fun at that doctor appointment. Clara Ross is in Texas. Vereki. Oh, and I love the eagle, as always, Kevin. Good to see you again. Am I saying that right? I don't know if you told me how to pronounce it. Vereki or Vereki? Hello, Stephanie Joy. I got medically approved for SSI, but I'm going to be disqualified until I downspend my money on a debit card. Ooh, yeah, you should have been taking care of this business before. I'm above the 2,000 limit, which I was unaware of. Yeah, you should study up before you handle. When you're going to act like your own lawyer, guys, you got to study up. You're just going to shoot yourself in the foot here. You could have had SSI back benefits going back since you applied, Kevin. I feel for you, but now you know. So you got a year. You're not going to get SSI. What is the dealio? I mean, if you could poop away your money so you can get a piddly SSI, or maybe you could do something smart with the money that you have. Like, what did you? I mean, you had a lot of money, but for some reason you applied for welfare. That's confusing to me, unless what you had was like a few $1,000s more than the $2,000 limit, in which case, yeah, I get it. And it was just being, unaware of what SSI is and the rules. If you have substantial money, but you do need SSI, you need the Medicaid, all that, consider spending it on something instead of, what's the word, whisking it away. I used a little different letter in the front there, so as not to offend. Do you own a house you could pay down the mortgage? Do you need a new roof? Do you need a new car? You can have one car. It could be brand new. Do you need a new computer? Do you need, things that will, the ones, the latter two are not my first choice. If you have a mortgage, and you could pay it down, or if you have enough money to actually put down on a small affordable place that you could otherwise carry the cost with, Kevin, on your SSI. There are things you can do where you don't have to throw that money away. You don't have to eat it like a bunch of bonbons. I hate to see people have to waste money when you could spend it in a way that's going to benefit you for the rest of your life. Paying down a mortgage is going to benefit the person. They could even pay off a mortgage sometimes. You have to get rid of the money. You may as well do it in a smart way. Now you have no mortgage. So now that 967 is free and clear, you don't have to spend $600 on your mortgage anymore. So there's ways to do it that I would really recommend. Sometimes I know an SSI client who had a house, needed assistance paying the mortgage, which is a pretty low mortgage, but when you're not working for years due to severe impairments, so was being helped with the mortgage and technically has to pay that back, but he's just going to do it slowly, I think. With a friend, sold the house that he had that had some equity, and the equity was used as the down payment on the new house, which maybe costs twice as much as a down payment. And the roommate, co-owner, will be handling the mortgage on the half that friend didn't pay in terms of the down payment. So they couldn't buy the whole house for cash, but he used his half to buy half the house, or nearly half the house. So now he's never going to have, the SSI should be free and clear. And in theory, maybe shouldn't even be paying any of the mortgage, or should only be paying a very tiny part of it. So anyway, things to think about, Kevin. I don't want to see you waiting a year. If that means you're going to be whistling away the money on silly things, that won't pay you back in spades later. Buying down a mortgage does that. Putting down on a house, if you can afford the carrying costs, might do that too, because eventually that house will be paid off, and now you have your SSI is not going to a mortgage. All right. Michelle M. Part 1. Rheumatologist. Yeah, she's smart. She knows somebody's got to label these things. Rheumatologist has my vitamin D level normal now and says they can't move to part 2 of my care until I'm off cancer meds in 1.5 years. I told them I want to come in 6 months for blood work. Okay, so let's see what number 2 is. That's Ness, you're welcome. Michelle goes on to say they were going to have me come back in a year, but won't it look bad to SS if I'm not seeing them for a year? Made my 6-month appointment anyway. Well, I don't know what your rheumatological problems are. I mean, sounds like you have cancer, so I'm not really clear. If you have a doctor, I mean, it is nice if it's the kind of rheumatologist, if you have rheumatological problems that you just can't treat with medications, if they will monitor you, yeah, just say, I'd rather you monitor me and just evaluate me every 6 months. So just make me more comfortable. That might be an avenue you could do just to get in there so they can hear your complaints. They can evaluate you, see what your range of motion is. If it's limited, now you have documentation of limited range of motion, in the interim. Spine surgery journey. Just started recon, signed with attorney. Good for you. Good, good, good. Looks like they didn't have all my medical records and this is still spine surgery journey. And I still have to have more surgeries, been not working for 12 months. Yeah. Well, fingers crossed for you, spine surgery journey. I do hope, you get this overturned, right? Reverse. Stephen Pomeranning says, there's a delay. I'm not trying to hold up your stream. I was only answering no worries. You're never holding up the stream. I was only answering the questions you were asking earlier in the show, but I don't think you saw them in real time. No worries. This is just the way it is. They scroll, sometimes when Shan is here, she'll scroll up and scroll down and try to get the question while I'm answering one or whatever. But that's just the nature of the beast. Don't even worry about it, Stephen. Everyone does that here. So no worries. And you could post whatever you want, whenever you want. It is totally fine. Jason Grogan. Hi, Jason. Just started SSDI application process and felt like my legal team is on point. Indeed. And everybody should have that feeling. Right, Jason? Taylor says, no, it said Trump is turning up the heat for long CDRs and wants them way more often. Ironically, there's been no Social Security rule change. So you got to be careful what you listen to, Taylor. I kind of think there's other things going on that you might be listening to. So just try to take heed. But you're gonna be, of course, as always, we've known this. This has been going on for years and years. Just go to your sources, the real sources, I would suggest. And again, CDRs are nothing to be afraid of unless you are better, guys. It really isn't. They rarely get flipped. It's only for people who are being sloppy and not taking care of business. Sometimes they don't realize they should be. Sometimes they've maybe fallen into such a depression they don't, but that's going to come and bite them in the butt. So sometimes you just got to pull yourself up and do it. You continue treating because you're disabled. There's a reason why you were, and if treatment doesn't help, which is always a response I hear, you can and should be going for monitoring to show that your complaints still exist and try to be compliant with medical recommendations that might help mitigate some of those symptoms. Okay? Seriously. If you are still disabled, do not be afraid of a CDR. Just be responsible with your follow-up, guys. That's all. And Taylor, by the way, it said, what's it? What's it? Your internet? You gotta have an authoritative source, like show me the video of the speech. It's just, there is a need for responsibility within the Social Security Administration, and CDRs are how it's done and how they have always been done. And sometimes there's more, sometimes there's less. There's different policies that go on all across the way. Do you remember in 2010 or so, there was or was it 2011? There was a Kanash, an unspoken little supposed, although ALJs confirmed it off the cuff, that the big guy at that time wanted to see decisions changed so that there would be more denials. And there you have it. And then we got more denials. It all happens wherever. CDRs are not the thing to worry about. CDRs are not the thing to worry about. You're welcome, spine surgery journey. Taylor says, oops, that's a repeat. Again, it. What is it? Big machine, truth-telling machine, or, it. Okay, Jason says, so with SSDI, you are considered dishonest in their eyes on all accounts unless it is on medical record? No, not at all. What made you think that? It's a matter of proof. So put it this way. Part of the evidence is what you say, like in your statements, like your function report, your application statements, whatever. And then the law that we all vote in, via our Congress and everything else, and the regulations require that the foundation of evidence You cannot prove disability without it being founded in the medical evidence. Medical evidence. So what we say is not medical evidence. That is non-medical evidence. And the useful part about it generally, Jason, and the irony is, like with the function report, I always say it can be used to sink your ship. It's not going to be used to win your case. And that's fact. It won't be. If a judge is inclined to find that your medical record is strong enough to support an award, so long as your function report doesn't sink that by you saying, well, like, what do you do from the time you wake up to the time you go to bed? Well, every day I have to run my 10 miles. You know, if you say something like that, yeah, well, no, you're not being dishonest, but you are going to lose your case, probably, right? I always say function report is really about protecting when you have protecting your win and not sinking your ship when you have the medical evidence that is required. It's not someone's choice. You can't just hear someone say I'm disabled and then smack them a big piece of the Social Security fund, right? It's got to be through medical evidence, because think about it. 95% of people would probably then claim disability when they're not. And I might be one of them. Just kidding. But you know what I'm saying? I know it's frustrating because it's a very high bar with the medical. And I think part of the problem is because our medical providers are horrendous, for the most part, in recording what we complain about. Their physical exams seem kind of shabby if they do them. And the fact that their default answers that fill up their progress notes and everything in the record for that visit, all defaults are within normal limits. Default within normal limits. Oh, so if they don't go in there and click on it to then take the effort to type in what you complain about, you are within normal limits and you did not complain about that problem. So there are reasons why the medical records are crappy, but it has nothing to do with the law on that. How is malingering proved? Oh, let's say someone complains of a 10 out of 10 pain, but they just drove an hour to the ball game. Someone might not believe that they have 10 out of 10 pain. Little signs and things like this that show up in medical records, because a lot of people toot their horn at their doctor's offices. They ignore that video, or they've never seen it, where I'm like, loose lips sink ships. Keep your mouth shut. Lingering is when there is no basis seen in the medical record for there to be such pain that is alleged. It's not necessarily malingering. Sometimes it's another cause. Like if someone has fibromyalgia, there's not a blood test about that. And that's not going to show up on an MRI. So people with fibromyalgia, I think, have been given the short shrift oftentimes, and some people will say hypochondriac, malingerer, when it's not the case. It really is a very misunderstood disorder, and it is a recognized impairment for Social Security disability. In fact, you'll see it in a lot of ALJ denials. They will acknowledge a serious impairment, serious MDI, which is one of the requirements, severe MDI, one of the requirements on one of the early steps of the sequential evaluation process, and then they will attribute no limitations to it. Or they'll say, well, in conjunction with all the other ones, that person can only do medium work. You know, the fibromyalgia limits them to 50 pounds of lifting, 20 minutes at every hour. It's silliness. But it's going to be, have you ever seen someone be a malingerer, Jason? I mean, think about how we use our circumstantial evidentiary discretion as people, and so do adjudicators and fact finders everywhere. There are, and usually, I will say this, I don't see decisions say malingering, by the way, because it's offensive. So, and they don't even use the word lacks credibility when they're talking about, particularly if they're talking about a claimant, but probably also when they're talking about doctors. They now say, not entirely consistent with the record. Not entirely consistent. Same thing. It means they don't believe. They think you're overstating your symptoms and stuff like that. Okay. But going back to it, Jason, they don't think, it's not a matter of dishonesty. Does the medical evidence get them over the hump needed? And if so, is there anything else in the record that would belie that they are disabled? Like, did they say they jogged 10 miles? You know? So I know it's hard. It's hard for people to consider the way it's looked at. I mean, being a lawyer for a gazillion years and doing other areas of law, including personal injury and insurance defense, the flip side of personal injury, we dealt with this stuff all the time. Totally in a different context, of course. Okay, Spicy. Hi, Spicy. I love hot peppers. Although I'm thinking my stomach might not be able to tolerate it anymore. I think my genes of ulcers that my father had is coming down on me. Okay, Spicy says, if your date last insured runs out prior to being awarded SSDI, if your date last insured runs out prior to being awarded SSDI, and you are required to pursue SS, but you then turn 62, yes. Will you be required to take early retirement Unfortunately, yes. When you are on SSI, if you have access to Social Security or any other insurance proceeds that you have dominion and control to take, you will have to be, they will be taken into account. So you could either stop everything and just wait. If you want to have an older, bigger Social Security retirement, you could just stop SSI and not be held accountable for the early retirement or not. So it's an unfortunate reality. And I'm sorry about that. It's true. It's true. Jason says, I, for one, have worse days than new normal days. Yeah. And that's not a bad thing to pay attention to, Jason. What are your, what's a bad day look like? What's a good day look like? And where's the breakout? How many days a week are bad? How many are good? Usually when someone's talking about good days and bad days, it's not like I have 2 bad days a month. Usually it's something worse than that. Usually it's on a weekly basis. They're enduring. Ryan Perez, hi Ryan. Does collecting SSI or SSDI in your fees for 5 years affect how much you get in when you collect SSR and go back to work until you're 67? Not per se. However, to the extent that you maybe would have earned 100,000 and now those years of zero earnings, the zeros won't count against you. That's not going to be counted in your top 35 years. But if you would have made 100,000 that year, and that would have been your high years, that 100,000 is not going to be part of your high years. So to that extent, do you see what I'm saying? Like you have 0 years, presumably, unless you worked a little bit, which is legitimate and fine if you follow the rules, went on SSDI. Those 0 years do not count to drag down your 35 years of lifetime earnings. So if you had 25 years, let's say 30 years of work and 5 years, I'm trying to see how my numbers work out here, thinking off the cuff. Bottom line is the 0 years, those zeros will never count. If you have other years when you're not considered disabled and they're zeros, they could be part. If you don't have 35 other years to count, those years could be worked in. Not if, and it's only between the ages, I think, of 18 and, I want to say 18 and 62. It could be 21 and 62, but I think it's 18. Don't hold me to it. It could be 21. So it's those years that they would grab, I believe, the zeros from, if any, but not if you're on Social Security, Disability, or SSI. And if you work after 62, those can help you too. So if a year you make at 63, you make more money than one of your lower years, it's going to boot that one out if you're already at your 35 years. So I don't know if that really helps. It's kind of roundabout, right? But the zeros do not count as zeros in the calculation of the 35 years. They won't be used. Thankfully. God for small blessings, right? RIP DT. Well, we're trucking along here, guys. It's already 2:35. Hello, Stephanie. Hi there, Rip. My ALJ didn't mention any of my symptom testimony in my denial, but for my hand impairment, he said I consistently had a normal gait. That doesn't have anything to do with my hands. You're right. That sounds a little sloppy. That decision writer maybe needs a little training, don't you think? I hope you're appealing it. If it's appropriate, I can't speak to your case, but that certainly does seem to be a peculiarity. And I think maybe ignoring testimony was not wise. He could have mentioned it and brought up the things you said and said, all this has been taken into account, and then gone on to say, I put strong weight in this medical record right here that says blah, blah, blah. Yeah. You know, I mentioned this at the beginning, guys. There's a video coming out. It's about a new court case. It's an unpublished case, so it's not actually going to be like precedential in the circuit it's in, but it's very useful. And it focuses around fibromyalgia, but, which is kind of like the redheaded stepchild of impairments in the SSD world, but it's about how the judge disregarded many things. And I think it can be useful for so many other impairments. So I do recommend if you catch it. It's going to be, I think, in the next week coming out. I just did it when I was able to go through this summarization of this case that was provided me. So I really liked it because there's so much fibromyalgia and it is very frowned upon, even though it's officially not frowned upon. Okay. Valerie says, thank you for explaining. Just so everybody knows, I wasn't labeled that I heard about it and I wanted your input. I'm not sure what, sorry, Valerie, I forget what you were even talking about. RD says, I had 5 surgeries prior to my filing date. I am that classic self-employed person pushing through my impairments. I understand. Sections of my bladder were removed. You would assume I should be approved. I am 56. Yeah. Well, it might take more than just the bladder, but I'm sure you got that going on too, RD, right? If your attorney or representative hasn't discussed it with you, ask them about pursuing treatment for other impairments you probably have at 56, because we are not getting any younger, and you're right behind me. Gun Lover, good to see you. Hey, Joy, says Gun Lover. Question. How does Social Security determine the value of your work? The representative I talked to when I did my subsidy form and reinstatement of benefits told me it's not just the number. That's true. For instance, your number, right? You got the subsidy application applied to your earnings. If they just went with the number of your earnings, you would have lost, right? And this is what they probably mean by it's not always just the flat number. There are other things that one can use to say, but that number is not really accurate. I had impairment related work expenses, IRWEs, or I had, particularly for self-employed people, I had free help from my spouse, that would have cost this. And that's why I didn't do that part. And the money that came in, I never paid my spouse a salary for helping me, or the neighbor or whatever. So there is a bunch of ways. On the flip side, it's also why self-employed people often have to do a lot more detail filling out an 820, because they can kind of try, they can write off every expense in its mother and show something lower. But what if they're still working full-time hours? They just make crappy pay because they're not really good at handling their finances of their business. If they're working 40 hours a week, but they make under SGA, self-employed, and a lot of self-employed people do that to start, not disabled people, there's a lot of sweat equity that goes in. So they need to know if they're able to do that sweat equity, because that would mean that their capacities to work are not as impaired as they might be alleging. So to get a little nitpicky with us self-employed people, it's something to be very documenting about and be very, very exacting and follow and record how few hours you do work, and make sure that if you are, thinking you need to pull in an extra day because some need with the business, maybe you need to get someone else to do it, because now you're going to tip over those hours when it looks like you're self-employed, but you are working substantially. Gun Lover says, that's it about the value of the work you do. Oh, how do they determine that? They look in the market. If you're saying you're getting paid $5 an hour for something that's normally paid at 20, the value of your work is going to be higher than that. And by the way, that's really rare. I don't think I've even seen that in my entire 20 years. And I do a lot of 820s and 821s with people, both clients and consultations. And I've never seen the SSA come back and say that amount you're earning really doesn't reflect the value in the going market. It could happen though, but it just doesn't, maybe because it's just not often the case. It'd be like, let's say you're a lawyer and you're working for minimum wage. They're gonna be like, yeah, really, you think we're gonna buy that? Do you see what I'm saying? I'm giving you a really obvious example. Shell Mazarak, hi Michelle, good to see you. Thanks for being here. I missed out on over 6 months of back pay because my otoneurologist kept referring to my vestibular migraine as a headache. I know, they're so sloppy with their verbiage, right? And they're medical professionals. I didn't even have a headache, nor did I ever say that I had a headache. But that's what he apparently diagnosed you as. Although I would assume, Michelle, you had vestibular migraine eventually diagnosed. I wonder if this was the problem. And guys, you should really check your records if you're pro se or not, because I had a case where the onset was later than the person was really overly impaired for, but it was still kind of a gift because the person would be done with, and it was a younger person. So the judge really was, I thought really good about this because, what was it? I think it was Sjogren's. It was suspected for 3 years, suspected. And so the impairments that would be attributable to Sjogren were not yet due to a diagnosed impairment. And so this was used to not go all the way back to what we wanted, but we got really what the big kit and caboodle was when we expected a loss altogether, because it was a remote DLI case with a young person. You can't get worse than that. But so the date of onset that the judge determined, which worked for getting her SSD instead of having her be stuck with SSI for the rest of her life, was because they kept kicking the can down. So sometimes I think we have to get very pushy with our doctors and be like, I need a diagnosis. So there's no reason for something to take 3 years. I don't think. There were specialists involved, and they were all saying suspected. They all just don't look at the fact that it's been suspected for 3 years. So go in, do your analysis, and give a diagnosis. That's it. I think sometimes we have to be a little bit more, I shouldn't say aggressive, because that's going to probably get us kicked out of the doctor's practice, but very proactive, maybe complaining, maybe pushing, maybe begging, whatever it is. It's like, I need a diagnosis. It's one thing, we can't expect a diagnosis on those kind of ruling out other things until you can narrow it down and this is the only thing left thing. That does take time. But I would think if it's more than a year, I would start to get a little antsy. And I'm saying a year generally. I can't speak to all impairments. I'm just, speaking to the one I have, not the one I have, but the one that I was just talking about. But that can affect. And you're spot on, Michelle, because if there's no diagnosed condition, that Sjogren's is not an MDI, medically determinable impairment, until it was diagnosed by the doctors in the acceptable way that the medical profession does it, the medically acceptable method. So it can be tricky. It's all things that there's always many pennies in the air you're juggling, trying to make sure, does that cover, was there a diagnosis of that properly? I mean, there's so much that goes into it to make sure all these things are done. Michelle goes on to say that it was all dizziness, imbalance, vertigo, and falls, no headache, and he's a specialist. It's almost like he was treating it almost like epilepsy. But you said it was a migraine, but your head didn't hurt. Is that right, Michelle? So it was a special kind of migraine, like you said, the vestibular. Yeah, different specialists. And you probably didn't even know that was important, or you didn't even know he was doing that until it was too late, right, Michelle? Yeah, I get it. You wouldn't think you would have to be looking at that. Candy Brown, hi Candy, says, I spoke to SSA about my SSDI claim, stated my medical review was complete. I guess the SSA stated that the medical review was complete July 12th, and that it will be sent to the field office. Next week. My initial application was February 25th. How long is this process? Well, who are you talking to? Let's see. Oops, wait, sorry. Spoke to SSA. So you spoke to the field office. And they said, okay, your medical review was completed by the DDS on 7/12, and that it will be sent to the field office next week. All right, so you don't know whether it was a win or a lose, right? Award or denial. How long does this process take? It probably shows up in your SSA account. I think they're talking about like 15 to 30 days. And that doesn't mean whether you prevailed or not, though. Not from that language, anyway. So fingers crossed for you, Candy. I hope it's an award, nice and early. They do happen at 6 months sometimes. I love them. Hey, DJ Kenny, long time no see. Should I request a letter or fill out the limited ability forms from my longtime doctor that's been treating me over 4 years for chronic back pain, fibromyalgia, anxiety, and IBS? He's moving. Hopefully his medical records are competently articulated, and then you won't even need any of this. I really can't answer whether you should ask him for a letter or, quote, limited ability forms. I think you're talking about like a medical source statement where he could talk about, if you're moderately impaired or how long you could sit, stand, walk, those kind of more detailed task by task functions. Only because I don't know what his answers are going to be. That's a risk, because if he describes you as impaired, but for your vocational profile, you needed to be more impaired, he just sank your ship. I have a video on why we don't necessarily want, I don't recommend people just blindly send these things out to their doctors. Even the most well-intended doctor is known to put the fork in it, not knowing. But it's all up to what your doctor will do too, DJ Kenny, if he or she's going to fill something out. I mean, to be honest with you, there's back pain questions that one can be specific about. Pain and fatigue questions, which might be good for fibromyalgia. There are mental health, specific questions that are helpful with anxiety. And then IBS would probably be a super short set of questions about how much you're in the bathroom, and perhaps if there's pain outside of that, and how long you're in the bathroom, because that would be off task time. Sending a big blanket, cover everything kind of generic 10-pager you find on the internet, it's not what I recommend, because you just don't know what you're going to get, and then you're stuck with it, and you have to turn it in. So, okay. My attorney has not requested this, but I'm questioning. I was denied going through the motions. Yeah, I would definitely speak. If you have an attorney, definitely speak with your attorney about it. I wouldn't do anything behind his back, because you could be interfering with something that he has been planning and working on, and now you just killed it. So I would be careful. Yeah. Oh, Valerie says, yes, ma'am. I've been a member for 12 months. Time flies when you're having fun, and I hope to be here many more months. Me too. See you for the next 12, Valerie. I appreciate. Kevin Varecki, new member. Thank you, Kevin. Awesome. Definitely check in on those early access videos. And, don't be shy in the general area where I'll throw a post and there can be comments or whatever. I don't know if you guys can post there, but I don't know how that works. But I post a few times a week usually. Valerie McKenna, yes, I have more impairments, especially caregiving help through my state. I have caseworker and they go by phone. Yeah, so, yipper. Things don't always get better, right? But we have to try to keep them at bay. Sam the man. My cousin is 64 and she started early retirement at 62. Is it too late for her to apply for SSDI? No, but almost. So she can apply for sure. She can, if she took early retirement at 62 because she felt unable to work full time, then at 64 she files now. She could get retro for the last 12 months. If she should get a protective filing in this month, Sam. That way she has 6 months to get the rest of the application in. I don't recommend she wait that long, but I'm just saying it buys her time, and it'll be a protective filing. If she never gets in an application, it just disappears, and it's no harm, no foul. But she could feasibly get paid back to 63, and they'll give her the difference between the early retirement amount she was getting and the higher SSD amount. And then going forward, it will all be the higher SSD amount and no early retirement, which will also help her, full retirement stay as it is, which is what she will see pretty much with the SSD amount, because that's essentially the full retirement amount, except right now, because she's been taking early retirement, her PIA, primary insurance amount, has been diminished, and stopping that will help boost it back up, because right now, taken at 62, it looks like she was going to take 60 extra months of payments, and they had to scrape that off the top of her amount to make that happen. That's where the money comes from. And now she will have only done it for 24 months, because, or even less, maybe even 12, if she can prove that she was disabled at 63. But she's got to get that protective filing in now before the end of July, and then get to work on all the things that she needs to work on for that. Okay? I wish her the best. That's a great question, Sam. I appreciate it. Valerie asks, have you found those CE doctors biased against the claimant? If so, what can be done or how can it be handled? It's very hard to change bias behind a screen, so there's really nothing that can be done, at least not in the direct way. I do think there can be bias against disability in general. They're working, why aren't you? They got aches and pains, they're working, why aren't you? It's inappropriate. How to handle it? I would say if you have expressed reason to know that a CE examiner was biased, and that's going to be a little hard. Like, you're trying to read a mind unless they actually said something. I think more often than not what it might be is a CE doctor writes a report and it has some misstatements of facts, not of his opinion and conclusions, such as she was able to button, zip, and tie, and he never asked you to button, zip, or tie, which is reflective of finger dexterity. Never asked you to do it and never asked you if you could do it. That would then be a bald-faced lie for him to say that. And how dare he? So is that a bias or is that just incompetence? I mean, incompetence because he probably used a canned standard format letter and plugged in your name and your social date of CE and a few other things, and then missed some things he needed to take out because they weren't pertinent for that one. While I do think there's bias, and perhaps the people that wouldn't be biased wouldn't be incompetent, they would be very diligent because they care overall about people, disabled people, not disabled people, and the Social Security process and the integrity of the Social Security process. Christina, good late morning from California. Oh, I'm glad you're here, Christina. John's Travel Adventure. Nice to see you again, John's Travel. Filed my reconsideration appeal 1 month ago and already have a case manager, so hopefully it moves fast in the initial application. Yeah, I think things are starting to, in some offices, get a little better moving along compared to the last few years, right? And then not so much in others. So hopefully, eventually, they'll all get up on board there. Kevin Varecki says, they're talking about if I don't have to reapply all over again. They talk, but you're still in it, right, Kevin? Brown-Eyed Girl says, can you talk more about 59 years old with overlap autoimmune? I'm being sent to SSA medical evaluation and mental evaluation because I worked in legal firm. Yeah. It means you had a high skill job. So the higher skilled we are, the harder it is at 59 or any other age within the grids to prove we can't transfer skills to a more sedentary or genteel job than might otherwise be. I'm not sure what you want me to talk about overlap autoimmune. I mean, remember from the Social Security disability, we don't do the medical doctoring here, but from the Social Security disability point of view, it's all about the documented symptoms and the signs that are in the medical records that can support your statements about how limited you are. So there has to be kind of like a bit of an objectivity to it, which is hard with autoimmune. But if you have proven the autoimmune through objective tests like blood markers, that's very, very helpful. There is, diagnoses though that have to be equally considered if it's seronegative, but it's otherwise diagnosed, probably by ruling out things. So think about constantly how you are limited in your functioning, and think about how you're limited with the things that you would think are so simple that you screw up because of lack of focus, lack of concentration, can't stay on task, can't remember for squat, which is really important when you're working in a legal office setting, unless you're the mail guy just opening the mail and putting it in the basket. So the physical part is really, really important because you have to prove that you can't do medium level work, brown-eyed girl, if you're going to get those grids to apply to you. Medium level work is over 20 pounds, less than 50 pounds. It's quite a bit of weight, in my opinion. So that's where musculoskeletal impairments come in: back, knees, ankles, shoulders, because medium also is generally on your feet, because, as is light. So if you can just prove that you can't, for medical reasons, you can't be on your feet 6 out of 8 hours, that is part of that strategy also. But grid is the easiest way to win, and being high skilled, that's where the mental comes in great handy to show that, no, I couldn't, if you are relegated to sedentary or light work, which is required to win under a grid, you also have to show that you can't transfer skills to that sedentary, to a job that would be sedentary or light that you could otherwise do. And that's where the mental health conditions that you should be treating for with a therapist potentially, and maybe a psychiatrist or a nurse practitioner, ARNP, APRN, whatever it is. Because if you're treating for things that are psychological, such as anxiety producing poor concentration and racing thoughts, and you can't really think of anything else and keep it in your head very long because you're always worried about something based on anxiety, or there can be depression, where that is equally, people just don't retain. Their brain just isn't even sucking it in when they're enduring depressive times. So that all has to be found in medical records. Presumably, best mental health professional records is better than your PCP, who is not a mental health professional. So PCP is better than nothing, but it might not complete the picture. As well as, sorry, phone calls keep coming in. Okay, John's Travel Adventure says, my denial letter said they didn't have enough medical evidence or vocational evidence to approve my case. Okay, glad there are people like you who do this for us. Oh, you're welcome. Yeah, so maybe you need to do more. And that's the only part that you can do. So hopefully your representative can tell you, you need to pursue this, because of your complaints. We look at what you say your impairments are, you've been diagnosed with, or your feeling is in pain. You got to get it worked up. You got to get a diagnosis if it's not already diagnosed. And then you want to follow up with specialists. PCP can be the overriding one who does all the referrals, and you go to them regularly to kind of monitor the whole situation. But you want specialists for special problems. And that's how you're going to build that medical evidence that is thus far lacking to prove all of what you say. Not necessarily that disproves that you have the diagnoses, because that could be in your PCP records, but doesn't show any severity, because everyone's got diagnoses. Doesn't mean we're all disabled, right? I mean, I got them, and I'm still working. So, but the people that can't do it are the ones we have to show how you're not like everybody else. You're more severe. Hey, Ken. Ken says, got my fully favorable from the ALJ, then final review, went from field office and back to hearing operations on the SSA website. Oh my gosh. I wonder if this is another one of those, I don't know, glitches where that now I think there's definitely a glitch, guys. That wouldn't happen. So I think you just have to ignore those right now. Hopefully, with I don't know how many days this has been going on, but it sounds like there is a complete coding mistake or something, that these things are appearing to be back at the ALJ's office when they're likely not, or back on recon when it was at the ALJ's office and was supposed to be at the ALJ's office waiting for hearing, and now it says recon. So I'm gonna have to check some cases and see what I see, if any of mine are reflecting very strange things. I hope not, but stands to reason. Brown-eyed girl, over 600 days, still no decision for SSDI. So you're almost 2 years. Are you on initial, on recon, waiting for hearing? Where are you, brown-eyed girl? Shoob. Hey, Shoob. Joy to the world to you, too. Thanks for showing up. Maeve. All right, we're at the 2-hour mark, guys. We'll try to get to these last questions. Maeve says, fibromyalgia has been assumed to be malingering. Oh, it's so annoying, Maeve. whining, or psychosomatic by many professionals for decades. It's frustrating diagnosis to get. I know. And my heart goes out so much. I've known people with fibromyalgia, and there was a panoply of other impairments that often got in the way, and some of them are not with us anymore. I think it still is the redheaded stepchild, and it's grossly unfair. And I really wish they would do a better job at finding a diagnostic, discovering, inventing a diagnostic test that will show. I mean, let's say, for instance, like the skin sensitivities where even touching the skin hurts. There's got to be something that shows that there's something with those nerves. I would like to think that anyway. And I'm not, obviously I'm not a scientist. Or is it all just like that there's something, or maybe something in the brain shows something is different, the way that touch is affecting that pain sensor in the brain or whatever. There's got to be something. Because it just, and again, how rude is it, right, for the statements of malingering, whining, or psychosomatic? It's not. I think part of the problem is there is often an overlapping mental health now disorder. But as you see in that video that's going to come out, Maeve, and I don't know if you're, I don't know if you remember. I guess they probably already have it, but it's coming out within the week. Whether it's the pain that causes the depression, or it just happens to be a correlating type of thing where people do tend to have anxiety and depression disorders when they have fibromyalgia, like the same, whatever allowed them to get that, whatever, maybe it's a genetic thing, maybe it's an environmental thing, also affects those other things. So, and it is heartbreaking because on top of feeling that way and living a life that way, now people treat you like poop, and it gets me mad. The comorbidities are really important. Most people with fibromyalgia have other ones, and sometimes they forget to put them down because fibromyalgia is the big thing that's running their life, but those other things are going to be important, particularly for the reasons that we're discussing about here, how fibromyalgia is not treated well. Kevin says, what SSA told me is that I'm good for a year. After that, I'll have to reapply. Yeah, but you're not collecting it. What do you mean you're good? Yeah, you're good. They're not paying you. Sure, they're happy with that. You're saying unless you're fine not getting paid, and are we talking about the SSI monies again, Kevin? I have double the amount in my account so I can get it down faster. Still working part-time, which my lawyers know. Yeah, I have double the amount in my account. Double of what? I have no idea. You have 4,000 in your account? For goodness sake, just do it. I don't know. That's not even one that you can pay down a mortgage, right? Do you need a new computer? I mean, do it now, and you can get your SSI now. You're disabled. And with SSI, I believe there's other benefits that, some groups tag onto that, and that can benefit you. I'm not sure why you would. And by the way, your part-time work is going to, for every $2 you earn, $1 will come off your SSI as well. So just keep that in mind. I still think it's great to work because that will get you off of the SSI and into SSD, and you start earning those credits. But in the meantime, if you want to get the SSI, are you using the 4,000? How that goes so fast? It's like 2 weeks worth. If you have rent and food and gas and car insurance, I don't know. And me says, is a person denied without ever filling out a function report? They shouldn't be, I don't believe, but I'm sure it's happened. What I tend to see is, first of all, almost always the function report. I have had such severe case that the adjudicator said, listen, I'm trying to get him awarded without him having to do that, struggle through that function report. So, we already had the function report all prepared. It didn't matter. That was maybe one case in 10 years. So, by and large, there should be a function report. Sometimes they screw up, though. You get a sloppy adjudicator. Last few years, there have been some wonkies. RD says, thank you, Stephanie. Yes, I just had rotator cuff surgery. I know you've been going through a lot. Oh, yeah. You got the bladder stuff, the mesh, right? I also have tailbone and nerve damage impairments, all medical documentations from specialists. Terrific. Keep up with the follow-up on everything, so it's all there, right, RD? Spicy Question says, thanks, Stephanie. Wasn't 100% sure you would be able to decipher my question. I hope I did. Recently denied at reconsideration and trying to secure legal representation. I'm not the most patient and a bit nervous. Yeah, I understand. Well, you can always fill out our evaluation. We could see if we have an opening in the category you're in, whatever that category that ends up being, based on your evaluation. I know some are always waitlisted. Some are usually not. So just give it a shot. And then we can also, if you want, if we can't take it because we're full in that area, because we do a whole landscape balance, there's a couple colleagues that I might, be able to take a look at it for you if you want. And I'll give you their name and number and all that too. So I could send them what you send me, the eval, if you want. And then I can, if we can't do it, and then, you can decide whether you work with them or not once you guys discuss. So RD is doing his physical therapy after his surgery. Very, very important, guys. A note on physical therapy. I find it very, very valuable. It doesn't replace the medical doctor, but he or she usually prescribes it. And that's where you get all the descriptions from the patient about which hurts, this hat, and the limitations that the doctors give you like once a year. You know, if you have 12 sessions of PT, that could take you years to have that many visits with the specialist. And you just got it in 2 months. But boom, it goes right in the file. Yay! And at least we have something to draw and say, see, person's been out of work for a year, and now look at this pain is still going on, yada, yada, yada. Particularly if the surgery was, let's say, last year, you're always going to go through surgery right after. That's not going to be considered 12 months maybe, unless your shoulder was really evidenced as being really bad for the whole year prior. But let's say now you're a year out and you're having another bout of PT because it's still bothering you enough for PT to be covered by insurance. That could be really indicative to show the duration and that it's significant enough for physical therapy, limited lifting. It all affects that exertional amount you could do, which is always going to affect people at all stages, but very, 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 very critical for grid people over the age of 50. Capish? Rip says, yes, definitely appealing. As this ALJ said, I had surgery on my hands, but didn't receive any further care, but then later mentioned my rheumatologist who was treating my hands for possible arthritis. Yeah, you got it. Definitely appeal. When the judge or the decision misrepresents the events and the treatment, it's a good chance you could get that, I think. Yeah. He's potentially basing his decision on facts, not in evidence. Objection. That's what the internet does, by the way. They always present facts that are actually not in evidence. They're just like, imagine facts. I was approved for my IC, interstitial cystitis. Yes, okay, Snow White. I'm at a listing. IC does not yet have its own listing. Yeah, which listing? Did they give you the number? IC. We talked about that not long ago here, I think. Interstitial cystitis. I envy nobody with it. It's horrible. It's very, very painful. And I feel for you, Snow White. I hope it's getting better. I hope some of the treatments are giving you better quality. Kevin says, I can quit my part-time job now, but I wait until I get this money spent down. But again, each time I get paid on my card, I would have taken the money out. Right. Just get it down to, I think this is how it goes. First of all, you have to, how much you're making, right? And then for every $2 you make, so basically cut it in half and say that's what's going to come off the SSI. You could still keep working. I don't suggest you don't. If you could still get SSI with the work, you'll get less SSI, but you get to keep that earnings, and that work can be so good for you anyway. Not to mention, it can get you off SSI and onto S because you will finally get those credits that you were lacking. If you don't have to spend all. Do you have 4,000? You said twice as much. I'm thinking you mean 4,000. That's not a heck of a lot. Now, isn't there something wonderful that you could buy for get it under the 2,000? Maybe leave 1,500, and then every time you get paid, you have got to spend it because the first of the month is when you got to be under 2,000. They understand benefits popping in can pop it over, but by the first of the month, when you're supposed to be paying your rent, that's when it should be down. So keep it under 2,000. If it pops up mid-month, I think that's okay. I don't have this in front of me, guys, so double check. But it's the passage of the month, going in the next month. Do you still have that? Then you're over, and then you're not due for that month. And then if they send it to you, you have an overpayment, and that's a nightmare. So if you can get it down under 2, and then every time you get a paycheck, you spend it down to under 2. And if you are getting free rent, I suggest you make a rental agreement so that you are no longer getting free rent. Better that you pay your landlord, family member, $400 than SSA keeps $400. If that's what your situation is. I don't know. I'm jumping around here, but you can do things, Kevin. Brown-eyed girl asked, depend on state you're filing in. No, nunca. Where are you? Where is this coming from? Oh, no. You mean does IC and winning depend? Nope, not at all. This is federal. All the rules are federal. So it doesn't matter where you are, what state, etc. Doesn't matter. In fact, a lot of times you're adjudicated. There's so many times when an adjudicator is in a support office on the other side of the country. So you're not even necessarily going to have the adjudicator in your own state. But they all have to follow the same rules, same exact rules for determining disability. Okay. Oh, hi, Dimple's back. Dimple's in the house. DJ Kenny says, I only talked to my attorney's assistant. She crafted the follow-up letter after denial with my info. Well, DJ, someone's drafting a letter that's supposed to be from your doctor. Is that what we're talking about? I don't know that would be appropriate because now your lawyer, when he submits whatever the doctor signs, like a pre-drafted letter. That's getting a little leading. And if the judge knew, he would probably give it 0 weight. And the funny thing is, a recent rule, not in the last couple of years, but recent, at least because it happened in my time, when we send in something that we requested from a doctor, like a medical source statement, we have to explain that we requested it and what we requested. So he's going to have to say, I drafted up this letter of how I see the case, Judge, and I got the doctor to sign it. How much weight is that going to hold, right? It's not going to. It probably would have been better to do a form where he could check the appropriate boxes of how severe, so the answers are coming from him. And then you will say, I sent him the form. You know, the doctor didn't have the form or make up the form. I sent it to him and asked him to fill it out. Hi, Dee. Dee just received a call from her claim rep. My case moved to stage 4. Is this normal process? And is a good chance I get approved for heart transplant? Why did your claim rep call you, Dee? They don't usually call you to say your case moved to stage 4. However, heart transplant has a listing. So I'm wondering if you meet a listing, but in which case you wouldn't really need to go to stage 4. Step 4, if it's a sequential evaluation process. But what we were discussing earlier today is that when the field office and because step 4 in the sequential evaluation process is, can you do your prior work? If you're a listing level for heart transplant, that's not really going to be relevant. But the stages, the steps that they call them, coming from the field office, but that wouldn't be your adjudicator. So if you say claim rep, you mean the person that was working up your case, that requested function report and anything like that, did all the medical records requests, then that would be different. So I'm not really sure what's going on, but heart transplant, that's serious stuff, Dee. I think we just had a video on that, didn't we? I think so. Thank you so much for taking time to help us out answering our questions. Rip, you're welcome. That is very nice of you to say. Thank you. Christina says, don't forget to like the video. Okay, yeah, like it. Dimple says, I'm curious about the grid rules in meeting a listing. Age 59 and dealing with rheumatoid arthritis and osteoarthritis. Narrowing of joints in both elbows, deformity of the fingers on the right hand. Narrowing of the joints in both elbows. Grid rules, 59. You can't do medium work. You can only do something less than that. So even if you can do lighter sedentary work, that meets the rule of not being able to do medium work. Number 2, you are unable to perform your prior job. So you have to be able to prove that through medical evidence. And number 3, if you had skills from that prior job, prior relevant jobs within the last 5 years, if you had skills from that prior relevant job, those skills, you have to prove that those skills are not transferable to a job that exists in substantial numbers at the light or sedentary level of work that you could otherwise do. Yeah, you're either going to be at sedentary or at light. Let's assume sedentary for the moment. That's certainly under medium. That suffices. But you might have to prove that you can't transfer the skills you had to a job that would be sedentary. So those are the things you have to prove from the medical evidence. All righty. All right, we're getting down to the nitty-gritty here. Dimple also says, ChatGPT said that I have a 65 chance of approval on initial app. I don't know. Overall, that's not true. But at 59, what about a 59-year-old's win on initial? That could be true. If it's 35 or 38% overall, remember that includes all your little 20-year-olds too and younger people. So I would think that to get at 38, some groups have to be way more likely to win. And that's where the balance comes out at 38. So that could be true. That makes sense. You go, Chat GPT. Rip says, I Googled the CE doctor who I seen, and in other SSDI cases, he had diagnosed those claimants with the same diagnosis as mine. And I thought that was pretty strange. We all had the same thing. Rip, was yours the arthritis and stuff? Wait a minute. Let me just scroll up. Oops. Surgery on the hands. Did he say? I mean, a lot of people have those arthritises, so, or carpal tunnel hand problems. So they might have sent you to a hand specialist, and all the people that go there, that's the doctor for the hand problems. I don't know. Just throwing out that possibility. Dimple. So she's still working at the moment, having total knee replacement next week. So is that going to be your work stoppage date, my dear? Would it be not going back to over SGA work, perhaps, Dimple? Snow White says, what listing did you meet? Sunflower's asking Snow White what listing was with the IC. So Blessed says, I applied when I was 54. I turned 55 in the interim. Will that help me get approved? Could very well. There's more favorable rules. So if you don't meet the 54 rules, but you are able to meet the 55 rules, that will make a huge difference for sure. Colette Schumpert. How you doing, Colette? Nice to see you again. I was at 3 in the portal. Yeah, we've been talking about this all day. Something weird's going on. I would call it a glitch at this point. That's my bet. Anybody want to take another bet? Or do you think they're just reversing everybody? I don't know. Maybe it could be, though. Maybe there was some glitch where it was a mistake. Maybe somehow everyone was glitched and pushed to step 3 when they should have been at step 2, and now they had to bring them all back. Maybe there was that. Maybe it was the fixing. Maybe it's now the fixing of a glitch. Who knows? I don't know where you were at, Colette. She said, does that mean I've been in the medical review? Well, did it leave the field office and go to the DDS? That would mean you moved to the medical review office. If they sent you a function report to fill out, that would mean, yes, you had been in the medical review. If they sent you a work history report, same thing. Any other kind of symptom report for you to fill out, that would also be the case. If adjudicator called you, any letters you got that said disability determination services or something similar, as opposed to just strict SSA in the field office address, then you're in the medical office. Medical review at the medical office. Oh, thanks, Brenda girl. I appreciate it. John's travel had 2 strokes in 2024, and he sees a neurologist and also a therapist for depression. And my PCP has also written a letter so I can use a cane because of my balance and weakness on my right side. Depending on your vocational profile, particularly your age, John, you might have a good case there, right? I forget where you said you were at. Maeve says, when I was diagnosed with hypermobility, I said so, but fibro. He said, no, you have that too. The hypermobility diagnosis is part of a diagnosed effort, which also uncovered MCA's. It'd be interesting to get into, Maeve, without getting into it here. Most doctors, including psych, will say I likely have depression because of the chronic pain. Well, if you're not treating for it, it doesn't count. If you start to do even, a little bit of therapy, talk therapy, it confirms, because then you get a diagnosis from a mental health professional, and it can hold water. For those, remember the grids about not being able to do the prior work or transfer the skills from prior work to the kind of job one could ostensibly do, which would be sedentary maybe. Oh, he said it was hypermobility and not fibro. Interesting. Okay. Also, skin is not the only organ with mast cells, so if you have it, yeah. I can imagine. Yeah, our skin, we have various kinds of tissues inside as well. Ellie Bird. Can they start surveying me? I think you mean surveilling me with video and photos out in the world after my ALJ hearing just occurred. I feel I'm being followed at apartment parking lot and city garden plots parking lot, weird license plate. I would say if you just got awarded on ALJ, that is not the SSA doing that. So I would take heed if you're feeling unsafe, Ellie. I don't know what to tell you. But that wouldn't be SSA. Would be my guess. And if you're disabled, you're disabled, so don't worry about it. DJ Kenny, my wife is a middle school teacher with chronic IC, interstitial cystitis, now anemic, had an ablation recently that wasn't successful. It's terrible. I know. And she's still working. She's still able to work. God bless her. Karen says, I had 21 physical therapy sessions, I'm thinking, for my back and neck. I'm going to go back because of my balance. The consultative examiner did the walking test, and I don't know why I couldn't do it. Well, sometimes when we have neck and back problems, we can't do that. My neuro is going to do MRI, PCP. I'm doing MRI of neck. Good. I mean, you're working it up. That's good. Those diagnostics are super important. All right. We're getting a little long in the tooth here, kids. DJ Kenny says, at least that seems to be the case. I only talked to her. Yeah. You only talk to her? Sorry about that. Karen says the gait is ataxia, so more and more happens. Yeah, I can imagine. Ellie Bird, last question. ALJ offered me choice to offer a last words statement on my own behalf for her to see before completing her decision. Hearing was Thursday. She said 30 days her decision. Any tips what to say? Meaning you can write her a letter now? I can't, Ellie Bird, because I don't know your case. Sorry. If I represented you, that would be different. I would say, Ellie, if you feel, going back to it, sorry about that, Daryl. I would say, explain, she knows the medical evidence. So you can explain possibly, how you would never be stopping work in favor of Social Security disability if you had a choice. That your goal has always been to continue working till retirement. And, and then some of the detriments on the quality of life, perhaps. Things that you might have said there, because of the symptoms. Daryl Lynn says, went through recon, was denied, was up for ALJ, but they sent my class. No, none of this is normal, Daryl. We've been talking about this all day. Nope. There's something wonky going on. Definitely not normal. Yeah, Dimple. Particularly Dimple, since I'm trying to wrap my head around AI. So, yeah, so funny. Rip says, he diagnosed us with back strain. Us? You, yourself, and you? Who? Likely related to DDD, degenerative disc disease. I have severe stenosis that required surgery. Back strain sounds very mild compared to severe stenosis. So I'd go with the severe stenosis in terms of proof. I mean, the back strain, most of them heal. So that's not really, that is not a powerhouse terminology that we like to see. Dimple says, I would love to have my work stoppage date for next week. I've been pushing myself. I know. Remember what we talked about this, Dimple. So blessed, you are very welcome. Yeah, that hypermobility, so blessed has it also. I heard that's really painful in the joints. Ellie Bird says the hypothetical questions judge and lawyer ask the job specialist, that would be the vocational expert, about light work scenarios only. Nothing about sedentary. Does that mean she believes I could do sedentary? If there was no sedentary RFC hypothetical presented by the judge, then that's probably because she's going to find you can do light work from an exertional point of view. Doesn't necessarily mean that you're not disabled or to be found disabled, but you certainly can't feel super comfortable either way. And the reason why the judge stuck with the light is because the reason why your lawyer probably stuck with the light, he could make up a sedentary hypothetical for sure, but if the judge has already made it clear that he's not going there, you really want to hit hard on the light. So what extra limitations does your lawyer knows in the record that he could put out there and say, but how about that same hypothetical of light, but when the person can't do this or can only do this for so long, would that job be available, Mr. VE, Mr. Job Specialist? And that's how you try to cross-examine further to get to no jobs. And then hopefully there's enough evidence in the file that the judge will be like, oh yeah. Or if you're looking down the line at appeal, that's what we lawyers are supposed to be doing. He's setting it up so if the judge denies your case, he might have more fodder for appeal, for potentially, the appeals council finding an appealable issue. So, yeah. So Ellie Bird had her hearing a week ago, and she's under the information from the ALJ that there will be a decision in 30 days, which is very nice. That's a pretty speedy decision. That's good. Can't complain about that. You're welcome, Ellie. The attorney assistant about the case who's gathering my documents and preparing the case. I only talked to my attorney in the very beginning. Is this normal? Sadly, that is true. That is quite normal. We don't do it that way, but everyone does things differently. But so don't be thinking the attorney and the team is not working on your case just because the attorney doesn't communicate with you. It'd be nice if they did. I agree, but that's just the way. That would interrupt the golf game. Just kidding. Oh, you're welcome, Dimple. Valerie, have you ever had a biased CE doctor? Someone asked that above. Maybe it was you, Valerie. Well, they don't come out and say anything. Like, I'm against disabled people, so I'm going to shoot down your case when I examine you. So I do believe people are biased. I mean, I do. I think medical doctors are biased against disabled. SSD claiming disabled, not someone in a wheelchair disabled. I think CE doctors, being doctors, some of them are biased. They're just not going to share that in a way that would be obvious. So, but usually you can maybe pull out inaccuracies in their record. I don't mean conclusions because that's their dominion to make the conclusion opinion based on their examination. However, if they make statements about things that happened in the exam that did not happen, I would call them out on it. I would write a letter to the DDS and CC it to the SSA, and maybe even I don't know if that would be waste, fraud, and abuse at the OIG complaint center, but I would let it be known because that's a false statement that he's using to support his crappy opinion. And so that's not right. Tony P, thanks for all the videos you put out. Oh yeah, and the lives. It's a big help to me and many of the people on this SID. Well, I'm glad any little bit I can help. It's what I like to do. So thank you, Tony. And I'm so glad you won. Thank you, Valerie. Okay, guys, it looks like we are all set. This is one of our longer ones, 2 hours and almost 40 minutes. All right, sounds good. I hope to see you guys next Wednesday at 1 p.m. Eastern Standard Time. And come visit our videos, 12 o'clock noon, the dailies that come out. On Fridays, we have our fraud law review, which is always just like a little fun, making fun of the terrible situation when people commit fraud and crimes against Social Security beneficiaries or the funds, or use Social Security numbers for illicit purposes. And some of the cases are absolutely crazy. So that's just kind of like to me, it's fun. I know that sounds morbid, but I like Friday fraud law review. They're fun to go over. And there you go. And if you ever want to know what we did during the week, you can always listen to the Sunday Social Security Roundup, which comes out at 12 o'clock noon on Sundays. And we just review what videos came out the week prior. Okay? So hope to see you all there. Definitely feel free to like, share, and subscribe. I appreciate you guys. Bye-bye now.